Senior advocate Mahesh Jethmalani is joining us live on the legal implications of this interim bail which has been granted by the Supreme Court. Mr. Jethmalani, I appreciate your time. For the first time in India, a politician in jail has been granted bail for campaigning. And the Supreme Court has also said that 21 days here or there should not make much of a difference. How do you look at this order?
Well, I mean, in a sense, the court is right. The 21 days interim bail is not going to, heavens are not going to fall. But the point is that, I have a difficulty with the judgment on the question of principle, right? First of all, bail should never be given or refused on extraneous. There is a bail jurisprudence. The Criminal Procedure Code gives you some broad guidelines as to when bail should be given or when it should be refused. And a lot of it is left to judicial discretion, right? But, I just want to quote something, quote a little passage from Justice Krishna Iyer, who quoted Benjamin Cardozo, a very famous American judge, in the bail context. This is what he said. When you're talking about judicial discretion, how it's to be exercised. Judges, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight-errant roaming at will in pursuit of his own ideal of beauty or of goodness. He is to draw his inspiration from consecrated principles. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. He is to exercise his discretion, informed by tradition, methodized by analogy, disciplined by system, and subordinate to the primordial necessity of order in social life. Now, to give somebody bail because an election is ongoing and is an important election, undoubtedly, right? And listen, this is only an intellectual difference with the reasoning of the judges, right? There are no aspersions cast. I disagree with the fact that they passed an order based on an election without recourse to judicial principles. Then there is the additional fact, Maria, that this was a man who since October 23 has refused to obey 9 summonses. That is unprecedented. 9 summonses of the ED. Who gets this kind of indulgence? Right? Any other man who did this, right? There'll be no case for bail. Then after refusing, right, to obey those summons, he then dares the ED to arrest him. Right? Now, the Supreme Court, to each his own. I mean, if they really feel, because ultimately, Maria, it must be said, judicial discretion is a question of judicial conscience. And the judge's conscience feels that they can grant an interim bail. I'm not going to cavil against it. But there are some repercussions in this case. Okay. You're giving interim bail to somebody who flouted the law previously and dared the ED to arrest him. A. B is going to open floodgates, right? All kinds of people similarly situated are going to make demands for bail for elections. And don't forget, Maria, elections in this country are an ongoing process. There are many so-called federalists in this country who are going to say that we are more concerned about the state elections.
But Mr. Jethmalani, will you not say that in this particular case, the politician here continues to be a chief minister and hasn't really given up his post despite being in jail? There have been many cases from Lalu Yadav to Jayalalitha and even a recent one of Jharkhand Chief Minister Hemant Soren when they resigned before going to jail. In this particular case, Mr. Kejriwal is still the Delhi Chief Minister.
Yes, but that's a moral question. I mean, Soren resigned when he went to jail. Hats off to Soren. But Kejriwal hasn't resigned. In fact, the court, because he hasn't resigned, has said he shall not handle any official files in his capacity as CM. So while one may disagree with the court, right, exercise of discretion in this case, right, they've hedged it with sufficient conditions so that he can't misuse or enlarge the scope of his liberty, right? The simple ground on which he's been granted bail, in a nutshell, Maria, is that there's an important Lok Sabha election once every 5 years, right? This is the 18th Lok Sabha election. He was elected as an MLA. He was elected. He was nominated the CM by his party. So let him be heard in the public domain, because after all, elections are the lifeblood of democracy. So that's fair enough.
But you are also of the opinion that this will open floodgates. Mr. Jethmalani, the ED had submitted an affidavit last evening, and they had made an argument that right to campaign for election is not a fundamental right. One reading may be that this order makes the right to campaign a fundamental right.
No, listen. Again, I would not say that this judgment elevates it to a fundamental right. Right? Simply put. I mean, you can disagree with that exercise of discretion, and as I said, I disagree with that. I very respectfully disagree with that exercise of discretion. But the courts have not put it that this is a fundamental right. They have not said it's a fundamental right. They've just said that Lok Sabha elections once every 5 years is a very important event. The man deserves to be heard by an electorate which formally elected. That's all, right? In public. And in 21 days, he'll be back fighting for the very case in which he's got interim bail.
But the Supreme Court has also said that let us not draw parallels with any other case. So it doesn't
That's
really
true, because
apply
I
to
know-
other politicians who may be in jail.
Yeah, but so far there have been no other parallels to this kind of an order. So the Supreme Court is right, let's not apply other parallels. When other politicians come, similarly situated if they are, as Kejriwal is, and they are rejected, that their bail is rejected, then it will be a cause for complaint. Right? So far there have been, I think, 2 cases, Jayalalitha and Lalu Prasad Yadav, who were not allowed to exercise a similar right during elections. And they asked for it, but it was rejected by previous courts.
But they were not chief ministers when they were in jail.
That should not make a difference. That should not, see, that shouldn't, they were elected. I mean, Jayalalitha was an elected chief minister.
But she had resigned from the post when she went to jail.
Yeah, but the
And
fact
also
is,
in case of Mr. Lalu Yadav.
yes, but the fact is, right, that if somebody who's facing serious charges of corruption doesn't want to resign as chief minister, right? Fair enough, that's his conscience call. Other people did resign, so but this is not, according to me, that's not a significant difference, right? He is a CM minister. He's a CM. That's because he's not resigned. His moral convictions don't propel him to resign, given the predicament he is in. The other 2 resigned.
Okay.
They could have said we still have an appeal pending.
Since you're saying it will open the floodgates, what exactly do you fear?
Well, I mean, all kinds of people, not just people similarly situated, politicians slightly differently situated, right? I mean, Soren has a good case right now to come on the same ground. I don't know how the court will distinguish it. I haven't applied my mind to the facts of Soren's case, but the court will be maybe obliged to give him bail if he so applies for it. So unless the court is saying this is a one-off case, but there will be a floodgates of other people, at least similarly situated or almost similarly situated to Kejriwal.
My last question to you. The Supreme Court also says that the ECIR was registered in 2022 and he was arrested in March of 2023. For 1.5 years, he was there. So I think that's also a reflection on the nature in which the ED has been proceeding with its investigation.
Well, he was arrested in March 2024, Maria.
Yes.
This March. He was arrested
Yes.
early March this year. Or 21st March this year, I think.
Yes.
21st of March.
Yes. So for 1.5 years, he was there. That's what the Supreme Court says.
1.5 years, they didn't have evidence against him. You indict somebody on the basis of evidence collected during the investigation, right? When they had that evidence, they wanted to test that evidence and see his answer. They gave him a chance to come in first. Maybe he had an answer. Maybe if he had come for interrogation, right, and explained the circumstances against him, which the ED had got during the course of the investigation, right, he may not have been arrested, but they dared him to arrest him. He refused to come after 9 summons, and then he dared ED to arrest him. So then neither was he coming for interrogation, and then he was daring you to arrest him.
All right. All right, Mr. Jethmalani, appreciate your time. Thank you so much for speaking to NDTV.
Thank you.